Hi everybody, this is Arkady Frekhtman. I'm a New York City personal injury trial attorney, and today we're going to do a special episode where we're going to help you answer questions in any kind of legal hearing, whether it's a deposition, an examination under oath, a 50H hearing when you sue the city of New York. So get ready, this is going to be an exciting episode. And the idea for this episode is from a potential or one of our viewers. Her name is Kristen Howells, and she wrote today, just a few hours ago, she wrote a comment in our channel, and the comment was, I had my deposition today. My attorney called me after and said, I did great, happy face, and I owe it to you. Had I not seen your videos, I wouldn't have killed it. Thank you for sharing your knowledge. I appreciate you. I only won a battle, but I still have a war to win. But tonight I could rest knowing everything I have been through is justified. Thank you again. So yeah, that just gives me so much power and so much gratitude, because that's our goal, right? Our goal is helping serious injury victims and families. And you see, this is someone we help through our videos. So this is awesome. This is just absolutely great. But I was thinking, I've done videos before where I kind of generally touched on how to testify in a deposition, and it was helpful and people are using some of the techniques. But I wanted to go over some of the basics because I have my list, kind of like a template that we give to our clients. And I wanted to go over it with you because if you have a case and you're going to be testifying, it's important to be prepared for what's coming, right? So a deposition, usually it's going to be a deposition, but any kind of legal hearing is usually very similar, whether it's a deposition or an examination under oath or an examination before trial or whatever you call it, it's usually all the same. So usually it's just, you're going to give testimony, right? So they're going to ask a question and you're going to have to give an answer, and there will be a court reporter there, and the court reporter will type up a book of all the questions and all the answers. And sometimes it's also videotaped. So, but you'll know that if it's being videotaped. So usually the way that you prepare for a deposition is you just have to get comfortable and you have to understand what it is. You have to understand the process, and, and that's very, very important. And you also should understand the way that the lawyers are going to use the deposition. So the way they're going to use it is they're going to have this testimony, right? And then at trial, if you say something that's a little bit different from what you said in your deposition, they could impeach you with it, which means they could say, look, today you're saying the car that hit you was red, but back on 2017, when you gave your deposition, you said it was blue. So were you lying then or are you lying now? And that's kind of like an extreme example, but that's an example. And they can do it on a lot of different grounds. And then when they sit down, that's the cross-examination of the defendant, right? The insurance company's lawyer. Then your lawyer gets a chance to then rehabilitate or to do another redirect examination to rehabilitate you. But, you can't always rehabilitate everything. So it's always best to testify truthfully. And if you're not sure about something, it's okay to say, I'm not sure, but you don't want every answer to be, I don't know, because then it's like, well, this guy doesn't know anything, right? That's not good either. So it's got to be a balance. And it's also important to note that at the end of your deposition, you have an opportunity to review and correct your transcript. And there's something known as an errata sheet where you could make changes, but you don't want to go crazy with that either, because if you're changing everything, then it's like, wait a minute, because the way it is here in New York is that they read your original answer, they read the change, and then you explain the reason for the change, but they read both. So you can't make the change too drastic. And so, yeah, so basically it's that's the important thing. And the real important thing that I think, in a deposition for a client is making sure you understand the question, because sometimes people don't understand the question, or they think they understand it, but they really don't. And then they give either too much information, known as TMI, too much information, and it's not even answering the question. So then the lawyer may say, move to strike the part that's non-responsive, meaning part of your answer is not responsive to the question. And lawyers and judges and, they like to keep things simple in terms of like, look, I asked you a question. Like, for example, if I ask you, what color was the car? And you say red, well, that's responding to the question. But if you say red and it had four wheels, well, now the part about four wheels is not responsive to what color was the car. So I move to strike that as non-responsive. But in order to avoid that, just don't even give the non-responsive answer, right? Listen to the question, understand the question. You can understand the question, say it over in your head without speaking. You could even answer the question in your own mind, calmly without speaking in your mind. Just answer the question. Okay, I understand what they're asking. They're asking me the color. I know what I'm going to say. I'm going to say it was red because it was red. Okay, now I'm ready. Okay, red. And it's simple as that. And the fact that you paused, right, for 5 or 10 seconds, or even 15 seconds or 20 seconds, doesn't matter. All that time that you paused, that doesn't get recorded anywhere, right? Because it's a transcript. It's just a question, what color was the car? Answer. So the fact that you pause doesn't get recorded anywhere. So there's no penalty. There's no bad, nothing bad happens from pausing. So pause. And if it's in a videotaped, okay, so you took some 20 seconds, that's fine. I don't think that's going to hurt you in any way. So it's absolutely a good thing to do to make sure you understand the question, you know how you're going to answer. You've already answered it without speaking in your mind, and now you're going to answer the question. So it's important not to volunteer information, not to exaggerate, and and it's important also to be honest, especially about prior lawsuits or prior claims. Often people forget, or people say, look, I haven't had any prior accidents. And, and they have, and the insurance company has it because they do a full insurance claim search and they get everything on the person. So they'll know if you've had prior accidents. And that just means like, any accident that you had before this one where you were injured, or even if they ask, hey, have you been in any prior accidents? Even if you weren't injured, they want to know, right? So it's better to just tell them everything. And, they'll get into, sometimes the lawyer, it depends also on the lawyer, right? Some lawyers are more like anal and they're going to ask everything under the sun, and they're going to, they actually kind of dig their heels in, they want to spend the whole day there, or maybe even 2 days. Now there are certain rules on the number of hours they could conduct a deposition. But they'll get into some background questions, like in a personal injury case, like your marital history, educational background, religious affiliations, employment history. They could talk about previous residences, any arrests or criminal convictions, driving record, things like that. Sometimes they get into that. But another important thing to consider is that sometimes the questions assume a fact. So if a question already assumes a fact, you don't necessarily have to go with that assumption. And, some of the questions may innocently ask, and they can mistakenly assume a fact, but you might not agree with that fact. And you have to be alert to such an assumption on the part of the lawyer and asking the question. And then you have to, promptly advise him that you cannot answer the question asked in that way. So for example, if a question asks something like, they assume something, but maybe whatever they assumed is not even true. So then the whole question fails, right? So a good lawyer will object to that and say, look, I direct my witness not to answer. I direct my client not to answer. And that's kind of like the old, when did you stop beating your wife type question, right? Well, maybe we never did. Same thing in a personal injury case. I'm trying to think of a good example. It might be something to the effect of, who referred you to the medical clinic? And they they probably want you to say my lawyer, right? Because if your lawyer referred you to the medical center, well, now it's an orchestrated case, right? It's not a real case where you needed medical care. But the question, who referred you, assumes that somebody referred you. What if nobody referred you, right? What if you just were in pain and found the place on your own through the internet, through the yellow pages, whatever, by walking on the street and saying, hey, medical center, I need help, I need medical care. So that's an example for personal injury. And another caution are questions in the alternative, because sometimes a question is asked in the alternative, such as, was the traffic heavy or light? But maybe it was neither heavy or light, right? The question is assuming it was one or the other, when in fact it might be like moderate. So just, it's always better to answer the question in your words as opposed to adopting the words of the defense lawyer. I mean, sometimes the defense lawyer, if their words are accurate and you agree with it and you feel like that's completely 100% spot on, there's nothing else that I really want to add or change. So, you want to adopt him. You could say, yeah, I agree with that. But if it's not true, then don't agree with it, right? It's always better to answer it in your words. You're the witness, as opposed to some defense lawyer that's being hired by the insurance company to destroy and dismiss and, pay you as little as possible. So, you never want to agree with that. Another caution is paraphrasing by the defense lawyer. Now, some attorneys attempt to summarize a witness's testimony on a particular subject and repeat it back and ask the witness if that is what he or she is saying. But your testimony is rarely summarized exactly as you said it, and just missing a word or two can make a big difference. So listen carefully to the restatement of your words and don't just say, yes, that's what I'm saying, because, just like in the other example, questions in the alternative, was the traffic light or heavy? Well, maybe it was neither. And if they try to summarize, so you're saying that you only went to therapy twice a week. Well, no, maybe that's not what you're saying. Maybe you went to therapy twice a week for the first month, but then because you were in so much pain, it increased to 3 times a week, right? So that's not an accurate summary of your testimony. So just say, no, what I'm saying is, and then you could say it again, or you could say, look, what I'm saying, I already answered it. So why do I have to, rephrase it? Or why does it have to be paraphrased? Also, be careful with time, speed, and distance questions. Rarely can an accurate estimate be made of time, speed, and distance in an event that occurs in a split second, such as a car crash. So be sure that your estimates are reasonable if you are able to estimate. So if your estimate is very rough, say so, say like, I'm just, not guessing, but this is a very rough estimate. And if you can't make an estimate, you could say so as well, because bad estimates can be used against you very effectively by a skilled lawyer. If you give a completely wrong estimate, then like, for example, if it's like a question of who is at fault in a crash, and they say, well, how much time passed from when the other car started changing lanes until the impact, and you say, well, I think it was like 30 seconds. Oh, then they're going to say, in closing argument, they're going to say, wow, it was 30 seconds. That's so much time. They had so much time to avoid the car. Why did they stay there? That's just an example. But you want to be careful of time, speed, and distance questions. And beware of absolutes as well. Try to avoid absolutes such as, I never do this, I always do this, because absolutes typically give the other side more ammunition. And sometimes they'll ask you to do a sketch or a diagram of the scene. And, some lawyers will object to that. The only time that sometimes the judge will overrule an objection and allow them to do that is if they say, look, where did you fall? And you have to draw like a little check mark or a little circle. But you should be able to identify that if the photo shows where you fell. If the photo doesn't show where you fell, you could just say so. And there's usually not a trick to that. And if they're asking you to draw something, unless you're like a really good artist, I'd probably say no. And remember, like in New York, and I think in most states, your lawyer could also ask questions. So if, for example, my client is testifying and they do a good job, but maybe there's certain areas where I want to amplify something or I want to explore further, at the end of the defense lawyer's questioning, I could do a redirect and I could ask certain questions and clarify or amplify or add, or, that's completely allowed in New York. Oh, and sometimes also what the defense lawyers do is they ask you questions about managing the lawsuit. So what that basically means is they might turn to the summons and complaint, and they might say, look, is this your verification? And then, in New York, unless the injured person doesn't live in the same county as the plaintiff's attorney, then if they don't live in the same county, the plaintiff's attorney could verify it. But if, for example, my office is in Brooklyn, so if my client also lives in Brooklyn, well, the client has to verify it. So if the client verifies it, it gets filed. But a verification says, I've read it and I agree with everything in there. So then they could start asking specifics about the lawsuit, like, oh, do you agree with that the defendant was negligent, or do you agree that you lived at this and this address, and then that could maybe scare some people, because some people might be like, well, I don't know anything about a lawsuit, I don't know anything about legal allegations, and they might say, no, that's not accurate, or I'm not sure if it's accurate. but previously they said that it was accurate. So you should go over the lawsuit with your attorney. Usually there's not really too much of a trick that they could do with that, but I've seen some clients get like flustered with that. So it's just something that you could consider. And the other important thing is just to listen to objections, because if you listen to objections, then you'll know that as soon as there's an objection, you should stop speaking and wait for the lawyers to resolve the objection. And then once that is resolved, you'll either answer the question, or sometimes you don't have to answer the question if the objection is something that is proper, right? And then the defense lawyer will just ask another question. And you can take breaks, take a break to go to the restroom, or just a break for, you can't take a break when there is a question pending. So you have to be at the end of an answer. It could be something like, I'm not sure, and then, okay, that's the answer to that question. Now I want to take a break, and then you continue later, or then you could try to revisit it later if you need to confer about it. But you can't take a break when there is a question pending. So usually in a personal injury lawsuit, the questions will be about the nature and extent of the injury, what body parts were injured, what parts have healed, which parts of your body continue to bother you, what you cannot do that you were able to do before, the type of pain that you have, that you're experiencing, how the pain and the physical impairments impact your work, your family, your life, your recreational activities, hobbies. They're going to go through your medical and injury history, asking about prior injuries, whether or not they're related to the present injury, as well as all the treatments that you went to, what the doctors did for you. They can ask about medical expenses. Now, you don't have to know or remember every single medical appointment, right? Because you have the medical records, but you should know the major things. Like, for example, if you had surgery with someone, you should know, hey, which doctor did the surgery, when was it done approximately, things like that. The important things. There could be some questions about property damage if it's a car accident, about lost income or lost wages, if you're claiming that. And so then I have like a list here that I'm looking at my template. This is just a template for all cases. But I see like this is an actual example of a sample deposition that a defense lawyer will go through. And it's usually like they'll ask your name, your address, how long you lived at your present address, where you lived before, your date of birth, your social security number. Now, some of those are going to be off the record, meaning they're going to be redacted. Where you were born, if you were born somewhere else, when you came to the U.S., who you live with, your family, are you married, do you have kids, your immigration status, your work history, where you work now, where you worked on the date of the incident, who was your employer, if you lost time from work, how much time you lost from work. They could ask your salary, like your weekly, your yearly, whatever you know. Then, of course, they'll ask the date of the accident, the date of the incident, what day of the week it was, the time. So those things you should know. That should be part of the prep with your lawyer. Now, the important thing is how the accident occurred. If they ask you that, some lawyers will go through it with you. It's like, where were you looking, each second, or, some lawyers will just let you do a little bit of a narrative. Okay, tell me how it happened, and you get to tell your story. But in, for example, a premises liability case, oftentimes a lawyer might say, what caused you to fall? So there, it's very important to explain that if that's actually what happened, which probably it is, right? If you're breaking a lawsuit, that it was the defective, unsafe condition, whether it was like a misleveling, the hole, the water, whatever it was, that's what caused you to get injured. Because if some people say, look, I don't know what caused me to fall. Okay, well, now they have it in a transcript. What caused you to fall? I don't know. Say, well, why are you suing us then? And then they're going to make a motion for summary judgment to dismiss your case, and the judge will probably grant it. So you have to be very careful about that question. What caused you to fall? It's very important to explain that it was, whatever it was, the defect, the unsafe condition. You don't want to say, I don't know, because that's a way for you to, what I call sometimes, when I prep people, I say, so sometimes what this is you picking up, let's say, a gun and shooting yourself in the foot. So first of all, let's imagine there's a gun on the table. You don't have to pick it up. Don't pick it up. Let it lay there. And second of all, if you're going to pick it up, don't shoot yourself in the foot, So it's a pretty simple thing, but you got to go through this because oftentimes, like I said before, people don't go to depositions. People aren't lawyers, right? People don't give hearings, and so people don't know, and people just start talking, stream of consciousness, and they don't even know where they're going to end up, and that's what happens very often. And then the next question is, if they ask you what caused you to fall, for example, the next question is going to be, well, how do you know, right? How do you know that the hole, for example, is what caused you to fall? And some people say, well, I don't know. And that also is not so good. Well, how do you know? And the way that most people know is either they feel it, right? They feel the defective condition, or after they fall, they take a look, okay, what was that? And then they see the hole, they see the water, they see the raised portion of the sidewalk, whatever it was. Because if they truly don't know, and then again, why are you suing these guys, right? Why are you bringing a case? And then if you say, hey, my lawyer told me, then it looks like, hey, they're trying to orchestrate something that's not true. So that's never good. But that's something that usually, and then sometimes the lawyer will also get into specifics, like which foot slipped on the water, or how did you fall? Meaning, did you fall forward? Did you fall to the left? Did you fall to the right? Did you fall back? And then you have to talk about that. And they probably will ask you, where were you looking right before you fell? So most people look straight ahead, sometimes down. Nobody walks like this, right? Always down, unless you're like a penguin. You're not going to walk looking down all the time. Which foot slipped? That's just your memory. What shoes were you wearing? Were you carrying anything? And then this is a favorite that they're going to ask you, is how many times do you walk in this area before you fell? Like if you're really familiar with the area, like for example, if you fell in the sidewalk in front of your house, well, they're going to say, well, how long have you lived? You lived there for like 20 years and you walk there every day. So you should know that there's a hole here, kind of thing. So you have to be careful about that and think about how best to answer that. And then here's an interesting question. If they ask you, did you see the defect, whatever caused you to fall, at any time before you fell? Well, now it's like a double-edged sword, right? Because if you saw it, well, then you should remember it. You shouldn't have fallen there. But if you didn't see it, and if no one else saw it, well, then how are you going to prove notice? Remember, you have to prove notice in a personal injury premises liability case. And notice basically means that either somebody saw the condition, that the condition existed sometime before the incident, like a day before, a week before, because then they should have found it and they should have fixed it, right? If it's a dangerous condition like a hole, or that somebody complained, that somebody actually complained to the defendant, like to the super of the building, to the manager, whoever it is. So one or the other. So that sometimes gets tricky. I can't really give an answer that's general to all cases, right? That's something that you have to really work on with your attorney to figure out how are you going to prove notice. That's actually a legal strategy, right? So that goes to when prepping a case, and that's something the lawyer has to do. And that's very, very important in premises liability cases. Any type of apartment building, ceiling collapse, slip and fall, trip and fall, grocery store falls, supermarket falls, you always are going to have to prove notice. And that's essential. Without notice, the case gets dismissed. And they might ask you, have you ever complained to anyone about the unsafe condition? So that's just, again, you just tell the truth. If you have, you've complained. If it's verbal, then you just say that you've complained. If you have it in writing, then even better, like an email or a letter. Sometimes people complain with the 311 here in New York City, so you can actually get a public record of the complaint. It's stored somewhere, so that's even better. They may also ask, when was the first time you saw the hole, the defect? And, if they're talking about the first time generally, right, that could be like, hey, 6 months before, but you forgot about it, a year before, but you forgot about it, that's fine. But if they're talking about at the time of the fall, usually it's after you fell, right? Because if you saw it, you wouldn't have stepped in it. I mean, that's pretty much common sense, but, sometimes common sense is not so common. Sometimes people say, I've had clients, sometimes they say, hey, I saw it, but then I stepped in, but then it's like, wait a minute, then it'll be your fault. And then photos, usually with photos, it's very simple. They'll just say, have you ever seen this photo before? And they'll show you a photo. And does this photo fairly and accurately depict or show the location of your accident. And then you would say yes or no, and what's on the photograph. And then you can point to, hey, this is where I fell, or put an X or a circle, whatever. That's fine. They might say, do you know who took this photo? And you may know who took it, you may not. You know, when was the photo taken? Usually they want the photo to be taken as close to the time of the fall as possible, so that you could say that, hey, it looks the same as it looked on the date of the incident. Because if you took the photo, hey, 5 years later, maybe it's a completely different scene, then it's not really going to be helpful. So photos are usually your friend. There's usually not a trick to photos, but sometimes people do get a little bit mixed up. And then there could be questions about the bills of particulars. In New York, we have this, after the lawsuit, we have a bill of particulars where people answer questions. And the questions are simple, like, you know, what is your address? What's your lost wages? What did the defendants do wrong? What's the negligence? What are your injuries? And so they're legal documents which answer questions posed by defendants. And sometimes a lawyer will ask whether the information in a bill of particulars, or BP, is accurate, and whether you have read and understood the bill of particulars. But the bill of particulars will have language about what the defendants did wrong, and also a list of your injuries. And you might be asked to verify your signature on the document that was attached to the complaint, as well as the bill of particulars, like we talked about earlier, which is known as a verification. And they might ask you when you retained a lawyer to represent you. They can't ask you about what you discussed with your lawyer, right? Because that's attorney-client privilege. But you could just mention that you signed the document. Sometimes people sign these things, the bill of particular or the complaint, and they forget about it. So it's important to realize that they might ask you about that, and to do that as part of the prep. Questions about future medical appointments and medical treatment. They could say, when was the last time you saw a doctor? And, you know, just be honest, whenever that was, if that was a week ago, a month ago, a year ago. And then as you sit here today, do you have an appointment with a doctor in the future? Now, if you're trying to claim lost, future medical expenses and future pain and suffering, probably the answer will be yes, right? Because if you're going to have future medical care into the future, then you'll be able to claim future pain and suffering, and as well as future medical expenses. But sometimes people don't know, or people say no. And, you know, that's not, I mean, sometimes, you know, the injury is completely healed, so then it would be no. But for most cases, serious cases, it's probably going to be yes. And you don't have to, you know exactly when the appointment is, and, you know, the time, or who the doctor is. You could be general about it. Like, I have an appointment with my orthopedist maybe in the next 2 to 3 months. My doctor told me to follow up with him once every 4 to 6 months. So I'll be making the appointment. I'm not sure if it's already scheduled, or I might have to call to schedule it. You know, something general like that is fine. Past medical history, doctors you saw in the past, you can keep it brief, because defense lawyers want you to give them a list of doctors. What they'll then do is they'll request every medical record from like your birth until you fell, or until you had a car crash. Every prescription, because, you know, they bill by the hour. So this is just needless work. And, you know, I mean, it's good work for them because they're billing by the hour, like $500 an hour, but it's not good for you because your lawyer has to provide all these authorizations. And then whatever they find in there is probably not even relevant. I had cases where I was representing somebody who used to live in another country, like the Ukraine, and they wanted like some records from the Ukraine from when he was 3 years old. I was like, okay, good luck. Send it to the doctor in the Ukraine. I don't think they're even going to respond, but you see what I'm saying? Because they just bill. And because it's twofold for the defense. Number one, they get to bill by the hour, right? So they get paid. And number two, they might find something in there that's going to help them, that they're going to use against you. But there are certain records that are legally, that they're legally entitled to, and certain other ones that they're not even entitled to. So you want to be really careful. You don't want to give them something they're not entitled to. So yeah, be honest about it, but I would just list the doctors that are relevant to the injuries claimed in the accident that you remembered. Like, for example, if you fractured your right leg and you had a prior right leg injury, even 10 years ago, you might have to mention it. But if you had your appendix removed 10 years ago, I don't think you have to mention that. What does that have to do with a right leg injury, right? It's completely irrelevant. So, and the courts are kind of in line with that. So, and remember, the defendant's goal is to prove that your injuries are not caused by this accident, but were caused by some prior condition that you had. They want to just show that any way that they can get out of liability, they will. So for example, if they can say that, hey, you fell not because we had a hole there, but you fell because you were dizzy. So now if they have prior medical records confirming, hey, this person suffers from dizziness, they're going to be like, see, we told you, and they probably were dizzy on the date of the incident. So you just have to be careful with that, how you answer and what you give access to. I mean, there are certain things that you have to give access to, but you don't want to give unfettered access to everything. So there's case law on that and precedents from the courts. Or for example, they might say you fell because you didn't take the medication that you were required to take. So you just have to keep all that in mind when answering questions. Now, your injuries, they're going to ask about your first medical treatment after the incident, whether there was an ambulance, hospital, what did they do for you at the hospital? And then they'll say, when did you next seek medical attention? So that it's like a chronology, like a timeline of all the doctors. The hospital, the doctor, the surgeon, the physical therapy. Which doctors did you see? What did they do for you? What were your complaints or symptoms? And this is pretty much asked for all doctors, hospitals, physical therapists, medical providers. Who referred you to the doctors? We went over that, right? Maybe nobody referred you. If somebody did refer you, you could say who it is. As you sit here today, are you experiencing pain? How often? Is it once a day, once a week, once a month? Sometimes they'll say, describe the pain on a scale of 1 to 10. What are some of the things you were able to do before the accident that you can no longer do at all? So you can't do this at all. It might be some kind of sports or something very physical. And then what are some of the things that you can still do, but not as well as you could before this accident? And list as many things as possible. Here, it's like the opposite, right? Usually we say, hey, just listen to the question and only give them enough to answer the question. And that's true about like who's at fault and liability. But with respect to injuries, the more damages you have, the more impact this has had on your life, the more loss of enjoyment of life you can prove, the more money you're going to get, right? So here it's the opposite. Here, give as many things as you can. And sometimes you could even do some kind of catch-all at the end. Is like, look, I'm telling you whatever's at the top of my mind now, but I'm sure there are other things that I'd like to be able to think about it and maybe supplement later on, because this has really, been a lifelong, forever injury. It's really changed my life, and I'm sure there are other things that I'm not thinking of right now. So yeah, usually the more you explain how the injuries affected your life, the better. And because when the insurance company is going to read your deposition transcript, the more they see regarding the injuries and complaints, the more compensation they'll be likely to offer you. And some just general things are things like just general, like for example, how can an injury affect someone, right? So what are some of the things they can't do? Well, they might have trouble sleeping, standing, sitting for long periods of time because they have like pain in their back, and walking. So that's pretty much like, if you think about that, SSSW, well, you just covered like 90% of what somebody usually does in a day, right? Either you're standing, you're sitting, you're walking, or you're sleeping. So, and then household activities like washing dishes, moving furniture, cooking, grocery shopping, vacuuming, mopping, sweeping, cleaning, any kind of physical activity, that's like a catch-all. And then, of course, it depends on the nature of the injury. For hand injuries, it might be using a mouse, typing, writing, washing, putting on socks. For a leg injury, it might be climbing stairs, walking, running, carrying a heavy backpack, things like that. For a head injury, it might be multitasking, difficulty concentrating, orientation, impaired intellectual functioning. So of course, there are going to be different answers depending on the injury. And then, think about what you do. You could even do like a day in the life. Like I wake up, I had trouble sleeping. I get out of bed. Well, I can't put on my socks. I want to take a shower, but I can't really, wash myself because I'm in pain. And then just keep going through it from the time you wake up to the time you go to bed. Go through a typical day and answer, but do it in a way that you explain what you can't do or what you can still do, but with pain. And things like playing with children, sports, and missed time from work, social activities, dancing, going out for a walk, bicycling, playing a sport or a game, whether it's golf or tennis or baseball or football or basketball, whatever you like to do. Then they'll say, Were you ever in any prior accidents? So you have to talk about that honestly, like we talked about before. And have you had any subsequent accidents, meaning after this accident, were you in any additional accidents? They may sometimes ask you for your passport. And the reason they're doing that is they want to see if you went anywhere, like far away, and to say, oh, look, this person is so hurt, but they went to like Italy on a vacation. And then sometimes they'll ask, have you been to any vacations after this incident? So you want to be honest with that. Medical history, like we talked about already, prior medical conditions, ever convicted of a crime, not arrested, but only convicted. And they'll say, have you had any alcohol within 24 hours prior to the incident? Is there any medication that you're required to take that you forgot or failed to take within 24 hours prior to the incident? And also, did you take any medication? So that's usually a summary of most of the questions that they ask. But of course, each case has to be prepared as an individual case, right? Going through not just the template of most questions, but your specific case. So I hope this was helpful. Let us know what questions you have. If you need a consultation, just text me, 347-566-9595. Leave a comment. I hope this is helpful. I was inspired by that comment. It helped somebody in a shorter video, so I thought I'd do a longer video to explain some of the intricacies so I could help more people. Okay, everyone. Have a great day. Talk to you very soon.